Hi, everybody. My name is Matt Goldberg. This is the Harris-Sliwoski webinar on cannabis trademarks. Welcome. We're happy to have you. I'm your moderator for today's festivities. I'm joined by two of my illustrious colleagues, attorneys Fred Rocafort and Elijah Hartman, who together have a lot of experience with trademarks as well as ancillary practice areas like litigation, international law, corporate law, and so on. Couple ground rules in terms of scope. We got a few questions about some very interesting topics like patents and copyrights, and those may be the subject of a future webinar, but today is solely about trademark law and cannabis trademarks in particular. And it's such a robust topic that we may not have time to fit it all into one webinar. We've gotten some questions in advance, and that's how we'll start. But before I do that, I'd like to give Elijah and Fred the opportunity to introduce themselves and say a little bit about their practice. Why don't you start, Elijah?
Hi, everyone. I'm Elijah. I am a Seattle-based attorney here at Harris-Sliwoski. I've been focusing on trademarks for quite some time. I do everything from branding guidance to trademark clearance searches to kind of vetting marks for use in commerce and everything from trademark applications to prosecution and enforcing rights through litigation. So I'm excited to talk with you. I do work in the cannabis space as well. So a lot of my clients are cannabis clients, and I have even litigated trademark infringement cases between cannabis brands. So I'm happy to talk to you a little bit about trademarks in the cannabis realm today.
Thanks, Elijah. Hey, Fred.
Hi, everyone. My name is Fred. I am officially based out of our Seattle office, but in fact work from Florida. As is the case with Elijah, I have also been working on trademark-related matters for quite some time. Much of my experience over the years has been focused on anti-counterfeiting and the trademark implications of related to the protection of brands, but also have quite an active portfolio of trademark matters, both domestic and international. In addition to my trademark work, I also work with our colleagues in our international team on a series of other matters, anything from contracts with foreign suppliers to setting up corporate entities in overseas.
Excellent. Thanks, both of you. So maybe before we dive into the specific topics along the way, we could do a little bit of level setting. We don't want to be too basic in the webinar content, but we also don't want to be too advanced. And so the best way to compromise there is for us to just run through some trademark basics, just so we're sort of level setting, talk a little bit about what a trademark is, generally how one obtains one, and then we'll go on from there. So do you want to start off that process, Elijah?
Sure. So generally speaking, trademark is a little bit different than copyright or patent. A trademark is a word, a slogan, a logo, even music or sounds that are used in connection with a good or service in commerce, actually commerce with the public. And so the thing about trademarks are there is a use in commerce requirement. It's not enough that you just make a good, print a logo, attach it to your good. It's not like copyright, where with copyright, from the moment you create it, you have a copyright. With trademarks, you have a trademark from the moment you start using it in commerce. And there's actually a principle in trademarks that's the first in time, the highest in right. So the first person that starts using a mark or a slogan or a logo or a sound in commerce in connection with their goods or services is said to have a trademark. And what's really important about a trademark is that its purpose is to signify a source of goods or services and indicate product quality. And it's set to acquire goodwill with the public that really originates with the source of a brand. So people can associate the quality of a product with an original source. They can make good purchasing decisions. And that's why we grant trademark protection. And there are a bunch of different regimes for protecting trademarks, and we can kind of discuss them throughout today's webinar. There are benefits to federal trademark registrations that we'll go into, but even without a registration, a trademark exists to a certain extent when you start using it in commerce. If it's a non-functional thing, if it's functional, for example, it's the way something works, or it's a product design that has a functional element, that's in the realm of patents. That's not trademarks. That being said, there are trademarks that are available for trade dress, which is the overall look, appearance, and feel of a product's design. That can also be protected by trademarks. Something that's not functional, though. Something that's used in commerce to signify the source of goods and really accrue value for the owner of that brand or that trademark.
So if someone starts to obtain trademark rights by using the mark in commerce, as you're saying, what then is the process to go from use to registration on the federal level, let's say?
Well, you have to look at the reasons for wanting to register a mark. The basic areas of trademark protection is the area in which you're using it. We call that common law rights. So if you're using your mark in a particular county, you have a common law right that's first in time that beats out everyone else in that county for your use of that mark. And it's really geographically limited common law rights. And so the benefit to registration, whether it's on the state level or the federal level, is it expands the scope of your protectability of your mark or your logo or your sound on a wider geographic area, even in areas that you haven't used it yet. And one of the things that you have to go through is, if it's on the state level, you have to go through a registration process. If it's on the federal level, you have to go through an application process whereby your trademark is vetted and cleared against all the other trademarks that are out there to make certain there's nothing that would be confusing that already exists. So those are some of the benefits to doing registrations, is that it expands the reach of your mark. And so if you have plans on doing business in another state, but you haven't done it yet, you'll want to look into accomplishing a federal trademark application and even a registration so that you can really keep others out of the market from beating you to those common law places.
And we're getting a question here just from the group, asking us to distinguish common law protection from what? And I think what we're saying is distinguishing it from the registration that you might go and do state or federal. Now, Fred, not as many people, even lawyers, are familiar with trademarks on a state level. I think many people think of the U.S. Patent and Trademark Office and federal trademarks with the little R in the circle. Can you tell us a little bit about state trademarks and why they're particularly relevant in this space?
Absolutely. And before I do that, I just wanted to stress something that Elijah mentioned, which is that trademarks exist in connection to particular goods and services. And I think that, for reasons which we will explore, is particularly relevant in the context of cannabis. But this is something that is sometimes the source of confusion on the part of brands and clients that we talk to. They, very often will hear someone say, "I want to trademark a word," and sometimes there is this expectation that they're going to be essentially acquiring exclusive rights to all uses of that word or that logo. But in reality, the trademark rights arise in connection to specific goods and services, and that the nuances of that become really evident when we talk about cannabis goods and related services. But to your question, I remember when I was a law student, which was a bit of a long time ago, and when trademarks were discussed, there was essentially no discussion of state trademarks. It was just glossed over, a little bit of the same treatment that the blue sky laws get in our corporate law classes. And the bottom line back then was, why would you even, why would you bother registering a trademark at the state level when you can get a federal trademark that'll protect you across the country? Well, the emergence of legal cannabis industries in a number of states has breathed new life into the state trademark regime. And to put it, to summarize it, if, as Elijah mentioned, use of a trademark has to be lawful, or the use in commerce has to be lawful. Now, without going too much into the complexities of the legal framework we have in the U.S. regarding cannabis, which does present some gray areas and inconsistencies, as most of our audience will know, there are states of the union where certain activities involving cannabis are legal, and therefore it makes perfect sense for state law to also extend trademark protection to the trademarks used in connection with those activities. Therefore, registration at the state level, and more broadly, enforcement of state trademark rights, offers a limited, but nonetheless an actual avenue that brands that are operating in the cannabis space can use to have some protections over their trademarks, at least within the confines of the state in question.
Now, so what are some of on the federal level, what are some of the statutory problems with obtaining federal trademark protection that lead people to consider state trademarks when they normally wouldn't? Or don't we have statutes that make it a problem to obtain a federal trademark on a product that may contain THC or even CBD in some instances?
Yeah, so there are, in general terms, there are two main stumbling blocks for registration of trademarks or for registration of cannabis trademarks at the federal level. One is the Controlled Substances Act. Basically, as most of our audience will know, cannabis remains unlawful, and you cannot register a federal trademark, or you cannot register a trademark at the federal level in connection to goods or services that are unlawful. By the way, I mean, this is not a cannabis only issue. Right. You can't do it in connection to other controlled substances or other unlawful activities, right? I mean, if you this is a bit extreme, but nonetheless, it's still true that if you had if you offered services involving murder for hire, you can't register that trademark. That's obviously an extreme example, but nonetheless, the rationale holds. So you have the controlled substances prohibitions, and then you have the Federal Food, Drug, and Cosmetic Act. I hope I got that right, the FTCA, this trips up a lot of brands, because very often there is sort of this shorthand that's used where people say, look, as long as a product has less than 0.3% THC, then it's going to be okay. And well, that is the case as far as the Controlled Substances Act goes, because those products are then not considered marijuana for purposes of federal law. But then you have all these other prohibitions that really have to do with food and health safety, right? So, for example, if you want to introduce CBD into a food product, if the cannabis in question has 0.3% THC or less, then that's not an issue from the point of view of the Controlled Substances Act. But it could run afoul of the FDCA, and there's a lot of nuance there, right? So I'm just providing an overview. But those are really the big two when it comes to registration of federal trademarks.
And just to like break it down to its essence, it still remains illegal, right? Like it's not possible to get a federal trademark on an ingestible product that contains CBD or THC. Is that the right understanding?
Yes and no. I mean, there are more than one form of THC. There are a wide range of cannabinoids. So we have cannabinoids that are delta 8 THC and delta 9 THC. And so right now, the prohibition is on any delta 9 THC that's greater than 0.3% on a dry weight basis. But if you have other cannabinoids like delta 8 THC, you have the lawful ability, as far as I'm aware, to put it into smokables and to obtain a federal trademark registration for it, and to even put it into potential edibles. The problem with CBD, as I'm familiar with it, is that it was previously approved in a pharmaceutical drug, and the Food, Drug, and Cosmetic Act prohibits you from putting a pharmaceutical drug or ingredient into food. So that's why CBD gummies are technically afoul of federal laws at this time. And so you wouldn't be able to get a federal trademark for your CBD gummy.
So then let's talk a little bit about some of the ways that we have over time worked with clients and seen people in the marketplace obtain federal trademarks or apply for federal trademarks, knowing that you can't get one on cannabis now. We've been trademark lawyers for the cannabis industry for 10 years now, right? So we've been doing something. What have we been doing? What are some of the ways that people have tried to or actually obtained marks related to what kinds of products, and what sort of implications does that create for the folks involved?
Well, there was this kind of general philosophy where if you could get your foot in the door with a federal trademark application for something legal, that you could kind of wait it out till cannabis became legal, and then you would kind of already have a brand presence in the marketplace. So there are all these workarounds that we've been recommending to cannabis companies over the years, which includes tangential goods or legal services. So tangential good might be apparel or stickers, something that is technically lawful that you have your brand on, that you have an application for, and that you do an intent to use. So maybe you don't have sweatshirts yet, but you intend to use the mark eventually on sweatshirts, and you'll develop an apparel line that fits your cannabis brand's vision. So we would recommend that you file an intent to use application, kind of hold your place, so you can almost have a priority consideration for when you start using the mark, because you've got your application pending and processing. So
Elijah, can you just expand on that so that everyone's clear on what you mean by intent to use and what that is in contrast to?
Yeah, so there are two different types of federal trademark applications. There's an intent to use application, which is you're registering a mark that you intend to use in commerce in the future. And then there's an actual use in commerce application. The first important thing is that because it's a first in time, highest in right, the date of use is important. So while you have your pending application for an intent to use application, your protection doesn't actually start until you actually start using the mark in commerce, and you submit a specimen to the Federal Trademark Office that you've used it in commerce. Conversely, there's a trademark application where you are already using the mark in commerce. So you say immediately, I'm using the mark, you submit your specimen, and from the date you filed your application is theoretically when, at a minimum, your rights begin, as opposed to later down the road.
So Fred, this is a question for you. One of the questions we received ahead of time from one of the registrants was, and this is not intended to be a political discussion per se. It's really like a functional, practical discussion for practitioners. but we did get a question about what implications may there be for the Doge government efficiency, reduction in force, thing that's going on with the federal government. People are really curious whether that might have any implications for working with USPTO.
It sure could. Basically, well, first of all, there's certainly a lot of discussion amongst practitioners about what's happening at USPTO. But obviously, we have to be careful about distinguishing between what's being commented and what will actually happen, right? So with that caveat, assuming that USPTO is in line for workforce reductions, and by the way, there's a related issue, which is that even if there are no actual cuts, there might still be an impact as existing workers decide that they no longer want to be there for any number of reasons related to new management, et cetera. So there are a number of possible actions or trends that could in effect result in a workforce reduction. And if that happens, what you will have is a situation that is not great already, to put it mildly, getting worse. So we were talking about this before we went live. I mean, it's already taking, in general terms, right? It's taking more than a year to register a trademark. I mean, according to USPTO, the average time for first action on a trademark application is 6 months. So I guess if that happens with your application and everything goes exceedingly well, you might be able to get a trademark registered in about a year. But this is the situation that we have now. A lot of this is the result of the pandemic, when you had both disruptions to workflow at the agency and also an increase in the number of people that were applying for trademarks for a variety of reasons. And just as the agency seems to be slowly coming to terms with the situation, again, if their numbers are to be believed, they are making inroads into the wait times. But now you might have a situation where all of a sudden those wait times start to creep back up, and that's going to have real implications for trademark owners. Just to illustrate one example. So sometimes you apply to register a trademark, application gets denied. You make the determination that you're better off looking for a new trademark, or sometimes an applicant wants to try. They say, look, I really like this trademark, let's give it a try. Well, obviously there's a difference between having a definite answer in a couple of months as opposed to having an answer a year and a half from now. Now, my take on all this is that ultimately, while we can certainly bemoan what's happening as practitioners and as citizens, for businesses, there is a practical reality here with which you have to contend. And faced with this situation, I think the one takeaway is you have to be even more careful as you prepare your application and as you design your trademark strategy more broadly, to reduce the chances of applications being held up or denied because any steps you take are potentially going to take longer. And the other thing I'll say in this regard is that USPTO has had to deal with the legalization trend involving cannabis, just as many other government agencies have had to. You can imagine that 15, 20 years ago, it just wasn't a big deal at USPTO, because if someone did apply to register a trademark in connection to cannabis or a related good, it would just be denied, no questions asked. Now you have this sort of evolving area of the law, and the agency has had to respond. Whether the response has been adequate or not is something we can discuss. But there has been this growing institutional knowledge at the agency, which again, you might not agree with the way that they rule on certain matters, but there is at least a process in place, and now that could be impacted, right? You could have some people who were very experienced with regards to cannabis and related goods and services, and they might be replaced by people who don't have that experience and who have to build that up, and in the process potentially make mistakes. So there are definitely a lot of possible implications for the world of trademarks generally, and in particular for cannabis trademarks in this brave new world in which we're living.
And there are already pitfalls, right, Elijah, in terms of how long it takes to get through the process, and this whole idea of having a legal mark on some legal products, but I really know that I'm holding out to use it on my actual product, which is some THC, or other cannabinoid containing product. And I want to give us a chance to talk about some of the interesting cases that have been out there. And I'm thinking of a case that's called AK Futures versus TBH Supply. It's a Central District of California case. You can email us after the fact and we can get you sites and information on any cases we talk about. But Elijah, that case sort of illustrates some of the problems between trying to juggle these different kinds of marks and lawful use. And tell us a little bit about that.
Well, if I understand the case you're talking about, this is one of the cake cases. Is that right?
Correct.
Okay. All right. So, traditionally, and just to kind of back up for 1 second, and then I'll get into the cake case. There's all these steps along the way to a federal trademark registration. So say you have a lawful product. You've got a Delta 8 THC product. It's a smokable or it's a vape pen. You think you have a brand name that can really be successful. You register a trademark. The first thing that's going to happen is an examining attorney is going to be assigned in 6 months. And if they know what they're doing, you're going to get what's called an office action response. And that is a letter from the USPTO that says, we think your product might be illegal. There is a Controlled Substances Act problem, and we want you to identify how your product is going to be able to pass muster and get past this office action. And so you actually have to develop a response, answer their questions. You have to affirm that it has less than 0.3% THC by a dry weight basis, and you have to go through and answer the office action to overcome it. But let's say, like the AK Futures case, in the cake case, you have overcome the objection. And one of the things that the trademark examiners will actually look at in this process is they'll look at your tangential goods, your other goods that you're doing. They'll look at your website. They'll look at things that you're doing to see if you're using your mark in unlawful ways before they approve your registration. So in the cake case, they were actually able to get through that process and obtain a federal registration, as far as I'm aware, with illegal cannabinoids. And they found someone else using their mark in commerce, and they brought a federal trademark infringement litigation against them. And ultimately, the defendant in that case said, Your Honor, we can show that this brand name is being used on products that are not legal, that some of their products are actually have more than 0.3% THC, and they submitted lab reports and evidence, and Cake responded that we have all these lawful uses. Look at our lab results from all these other products. They're completely lawful. and the court decided that that was grounds to invalidate their trademark, and they no longer had a valid trademark because they were using their mark on unlawful goods. So it kind of raises the question of, even if you are able to overcome the office action responses, even if you are able to get a trademark for your legal products, if you're doing something unlawful with your mark, what is actually going to happen when you go to enforce your mark against someone who's infringing? Is it going to result in the cancellation of your trademark? So that's an important takeaway.
And this also relates to something we were talking about as we were preparing, Fred. There's another case. This is a TTAB case from May 2023, Trademark Trial and Appeal Board, INRI National Concession Group, because the issue that Elijah was talking about, whether the thing I think is lawful is going to be considered lawful by different regulators, Fred, that's not even true just for products that actually contain cannabinoids, right? It goes beyond that for products in other categories, right?
Well, this is actually a very interesting aspect of all this, which concerns the determination of whether a product is legal or not. And we tend to think that that's a relatively straightforward question, but it isn't always the case. One thing that I've seen with USPTO is with certain goods. Basically, the application processes have been halted, and I think that it with regards to some goods, USPTO is just saying, look, we just don't know. We there seems to be a gray area here, and we're going to wait until there is more clarity on this issue. So I see somebody asked about THCA. I haven't looked at this that closely, but I remember not long ago, I took a look at the USPTO register, and I couldn't find a single trademark that had been registered for THCA goods. Again, that was not necessarily, don't take that as an authoritative statement on what USPTO is doing. This also relates, I think, a bit to the issue of paraphernalia, right? And how even the same physical product can receive different treatment by federal agencies, not just USPTO, but also agencies like Customs and Border Protection, based on the totality of the evidence that's available. And I think this is another important takeaway that I would like our audience to leave with, which is that these trademark applications, and indeed any other dealings with the federal government, do not take place in a vacuum. And the federal regulatory agencies are going to be looking at all available evidence. And just because you say your product is of a particular kind or a particular description, it doesn't mean that the agency in question isn't going to look and find evidence that supports their view that, no, actually, this is drug paraphernalia.
Well, that's the issue, right? Is the sense that the applicant has or doesn't have of what the investigators, examiner, whoever it may be in a particular agency is going to do to find out. I mean, this National Concession Group case, I mean, what cannabis trademark attorney hasn't at some point tried to say, like, this is not for use with that, it's for tobacco, or it's meant for essential oils or something like that, and in this national concession case, Elijah, you talked about the courts or the trademark examiners looking at websites. I mean, what was going on in this case? They had a device,
right? So this was actually a TTAB decision. National Concessions, I believe, had a oil dispenser
Like the dabulator or something.
A dabulator, or baked, I think was the mark. A daberatus pen, as they called it.
The daberatus.
Daberatus. And on the face of the application, it was a lawful product. They said, this is for use with essential oils. We're making a dab pen for essential oils. There's nothing unlawful about essential oils.
Don't you dab lavender oil?
And the TTAB didn't buy the application. They started looking at extrinsic evidence to interpret the actual use that the product was designed for, and they determined it was for unlawful dabbing of THC. They looked at the company's website. They looked at marketing materials. There was even an article in High Times praising the product for being so good at dabbing. So this totality of circumstances that Fred was talking about is exactly what the TTAB did. And they said, this registration is going to be denied because this is actually, contrary to what the application says, illegal drug paraphernalia.
Would you have advised them to use a different name for the product?
You know what? In this particular case, I don't even think it was the name. I think it was their reputation in the community that really did it.
So this is not exactly in order, guys, but I see that we have a couple questions. We're known as a firm with expertise in international matters, and I see a few questions, and we got some before the webinar also. Maybe we just do a quick little detour, because we didn't really talk about, we were talking about federal protection, state protection, maybe we could be a little bit more precise. We're talking about United States protection, and that differs from protection in other countries. Fred, can you give us a whirlwind tour through that?
Yeah, sure. And I see we have a question. Someone is asking, what rights does my U.S. trademark give me outside the U.S., for instance, in Mexico? And I think this is a good starting point. So basically, the answer is none. Your trademark rights are territorial. If we really want to get into the weeds, I mean, you can look at places like the European Union, and they have some different rules, but basically a U.S. trademark it stops at the border, right? You can have very strong trademark rights here in the U.S., and the moment you cross into Canada, there's another brand that has those trademark rights. So these are national rights exclusively. However, with us lawyers, there's always some exception or some note that we have to make. If you have a U.S. trademark registration or even an application, you do have the option of applying for extension of that trademark to other countries. Not every single country in the world, only most countries, but not all, form part of the international trademark system known as the Madrid system. So, but it is an option. From U.S. to Mexico, you could certainly do that. So you do have that option, but it's important to keep in mind that when you do that, what basically happens is you are consolidating your trademark applications into a single process, but ultimately it's going to be up to each country to decide whether they register that trademark or not. So if I have a U.S. Trademark registration, and it has to be registered, I mean, in order to do this, it has to be registered at the federal level. I could apply to have that trademark extended to Canada, Mexico, and
Are you saying, Fred, that in order for someone to try and get a trademark in another country other than the U.S., that they have to have an existing U.S. registered federal trademark?
If they want to do it through the international registration process. So yeah, if you want to do it that way, you would need to have a federally registered trademark. But what ends up happening is that every single country that you designate will review the application, and you could have a situation where Mexico says, yes, we will register your trademark, and Canada says no. And then just to finish up on this topic, and kind of tying it with what you just said, Matt, you also have the option of applying directly with the trademark office in the country in question. So, for example, again, taking the Mexico example, you can also file an application to register a trademark in Mexico. And in order to do that, you don't need to have a US trademark at all. You don't need to use the trademark here. You don't need to have a registration. And one thing to keep in mind, and this is a bit of good news for brands in a world where sometimes a lot of the news aren't that great. When it comes to getting trademarks registered, many countries don't require you to use the trademark in order to register it. So whereas here in the US, you will need to show that you're using the trademark in order to get it registered, there are countries where that's not a requirement, and you can register a trademark that's fully enforceable, even though you haven't used it, and that can be helpful in certain situations. So yeah, if anyone has any more questions about the international aspect of things, you can reach out to me offline. Happy to engage.
Great. Once someone does all this work and considers all these factors and actually gets a trademark, I think it might be useful for us to sort of follow that life cycle through, right? So I get what's called a notice of allowance. Is that right, Elijah, from the trademark office, when I've sort of cleared all the obstacles that you were talking about and finished all the office actions?
Yes, a notice of allowance. And if you haven't done so already, that's your opportunity to file your statement of use and a specimen with the USPTO. And the notice of allowance will allow you to go to the next stage. Will basically allow you to move on toward publication. Does
that mean I have the trademark?
What's that? No, it doesn't mean you have the trademark.
Okay.
It means that your mark is going to be published in a gazette for review by other trademark holders who can contest your mark.
So it's sort of like a notice and comment type thing.
Exactly. But one of the things I want to mention, and to bring it back a little bit to the cannabis space, because I think we have a topic on that, is that one of the things that cannabis companies tend to forget is that just because you have a cannabis brand that you're using your mark and you don't even have a federal registration doesn't necessarily mean that you don't have to worry about infringing on some other legal brand. And so if you have a cannabis brand called, High Marks, and there's a famous brand out there that's for clothing or for sneakers that's called High Marks, that is still potentially trademark infringement. So it's really important that you as a cannabis brand, before you start putting a mark on cannabis, that you clear with the trademark attorney the mark to make certain there's no other famous marks out there that might sue you for trademark infringement or tarnishment of their brand. So you don't only have to worry about getting a trademark registration yourself, even if you're not going down that route, you don't plan on doing the application process, you just want to sell your cannabis in one state, you still have to be on the lookout for trademark infringement litigation against you. And that is, I think that came up in the Raw case, if I remember.
Yeah, let's talk about that case. And just for everyone's benefit, that's called BBK Tobacco and Foods, and that's a Ninth Circuit case from April of last year, and it involved a product that probably all of us have seen multiple times in multiple places, being raw rolling papers. So what was going on there? Either one of you guys.
Elijah, if you feel more, I mean, I have a passing knowledge of that case. You might have more, better input.
Yeah, so I just want to correct what I said. I think I said a notice of allowance allows you to go to publication, but I think it actually allows you to proceed to registration, your notice of allowance. So I just wanted to correct that. But the Raw case, cannabis trademarks and all trademarks, they protect not only the class that you're currently in, but your natural zone of expansion, where you might likely go with your mark. And so there's a company called Raw that sells rolling papers. And there is a cannabis company that is called Raw Garden. And Raw Rolling Papers sued Raw Garden and said Raw Garden is infringing on our rolling paper trademark. Now, Raw Rolling Papers, they're not selling cannabis. They're not doing cannabis products. And Raw Garden said, we're in different classes. I'm doing cannabis. You're doing rolling papers. There's no likelihood of confusion. But the court just recently determined that there was enough evidence to show a likelihood of confusion, and allowing the case to go to trial for trademark infringement.
Does that mean that the court is allowing, the appeals court is saying it's okay to go to trial on infringement, even though Raw Garden isn't making a competing product in the same class?
Yes, that's what the takeaway is.
And but I mean, maybe we could just like pause for a moment on that. And that's a fairly significant infringement ruling, right? Because is the appeals court saying, without saying it, that cannabis is in the natural zone of expansion for smokers articles?
Well, I mean, it raises the question if that advice we were giving clients back in the day about the workarounds for registering apparel was really actually good advice. If you get a trademark registration for apparel and someone starts using the cannabis with the same mark, if you have reasonable grounds to say that is infringement, even though it's not lawful to do the cannabis. And so I think that may be the potential implication here. It's still a little early to tell because it's being sent back, I believe, to the lower court for determination on infringement.
And it also was rolling papers, right? It's not a sticker. It's not a bumper sticker.
Right. It's not a bumper sticker. It's not clothing. It was rolling papers, which is for herbal substances. So there are theoretically legal cannabinoids that you could use raw paper with.
It's pretty interesting, right? Like it shows like the kind of the way it touches the real world and sort of the nuance of it, that raw rolling papers, which probably very few people use for tobacco or CBD only flower, right? They just won like a major decision last year in the Ninth Circuit, and cannabis is in the natural zone of expansion. That sounds amazing. But this dabulator thing, which you can use in a legal way, is just out, It's reconciling those things is maybe why you need a trademark attorney.
One thing, I mean, and this is certainly what Elijah mentioned about making sure that you're not infringing on others as well as minding your own rights, I think underscores another very important point that should really frame the entire discussion of this topic, which is that even though there are specific issues concerning cannabis when we talk about trademarking cannabis, that doesn't you can't neglect the fundamentals, meaning every other requirement that is in place, and every other consideration that is in place applies to cannabis brands as well. And I think that unfortunately sometimes the fact, I think some brands sometimes take the fact that they're operating in a gray area to mean that, well, there's just going to be risk in everything we do, so we're going to just give this a try. But I think that's not a prudent approach.
To your point, Fred, because this is something that we know is important, and we were talking about it, and you even said, Elijah, about what one of us said, like that one of the marks in one of these cases was baked, spelled BAKKED, right? And so there are these like general trademark principles that a simple misspelling of a word is not enough to give it distinctiveness, or if a particular mark is too descriptive or uses a geographical place name or a person's proper name. There are all these things that if you don't take into account, even if you don't get dinged on a cannabis basis, you'll get dinged on some other basis. And I think that's what you guys are getting at, right?
Yeah, I think when we're talking about infringement, we're talking about a likelihood of consumer confusion. So that means something that's similar in sight, sound, or meaning, that anything that can cause that consumer confusion could be a trademark infringement. So you could spell it with a Z, you could spell it with an S, you can have double letters, you can have numbers that look like letters, it can be in another language, and it still could be an infringement of a mark. So we get into this kind of situation where cannabis companies want to make goods that look really attractive to people. So they kind of create goods that are homage to other products on the marketplace, like children's candies or other famous brands. And even if it's spelled differently, even if it's a different product in a different class of goods, it still could be potential tarnishment, potential infringement of another person's brand, even though it has a different spelling or a different labeling. If it does raise that consumer impression between the two brands themselves, that creates some confusion or some association enough to damage the prior mark.
I just want to point out, Tim is pointing out in the chat that the raw case went to trial in December and the plaintiff won. And so I guess,
excellent.
Yeah. And so what's interesting about that to me, though, is, so not to get like too far in the weeds on a particular case, but does that mean that like someone thought that consumers were being confused that the weed grown by Raw Garden was actually produced by the company that makes the rolling papers?
I think what it means is that there was enough of a likelihood of confusion that this was associated with the Raw brand of products, associated with the source.
That word itself, right? Like we can't cover every concept here, and so we may not be able to get into secondary meaning, and but isn't raw a pretty basic descriptive kind of word?
Not really, actually. When you think about and trademarks, we haven't really talked about it, but trademarks are granted protection on a range of distinctiveness. You've got generic marks, which are just basically apple for apple. You've got descriptive marks, which are maybe like crispy chips for potato chips. They describe the product. Then you've got arbitrary, and you've got suggestive is in there as well, something that suggests what the purpose is but doesn't really describe it. Then you have arbitrary and fanciful, which are the most protected marks, something
like,
that's completely
like Xerox or Kleenex.
like Xerox, except Xerox is kind of a bad example because what happened with Xerox was it became genericized.
Coppertone, I think, is an example of
it became used so much that it defeated itself. Everyone was saying, make me a Xerox. But yes, traditionally Xerox would be a fanciful word that would be completely on the most protectable side of trademark. So raw, for rolling papers, it doesn't describe what the paper is. It doesn't say it's papers. It's not generic. It's not suggestive. I can't think of how raw would suggest to me to be a rolling paper product. And if anything, it's more arbitrary in the arbitrary realm of things, kind of like Apple for computer. So right. As far as the protectability of the raw mark, it was very strong protectability for the class of goods that it was in.
Interesting. We only have a few minutes left here, and so I want to make sure that we've had an opportunity to answer all questions here. You said, Fred, before that a few months ago or something, you looked at the registry and didn't see any, as far as you could tell then, you didn't see any marks for any of the other cannabinoids that are out there and are really popular.
At least not for THCA. I can't, like, it might have been a bit longer since I've looked at other cannabinoids.
And you know what? One thing we didn't get a chance to say that is worth spending 5 minutes on if we don't have. Meredith just said exactly what I was just going to say. That in the remaining minutes we have, maybe we could, Elijah, you could start us out talking about one of the classic cannabis trademark issues, which is naming the cannabis product too closely after an existing popular brand that may be candy, it may be for kids, it may be both. That's sort of the Skittles issue, we could call it. That's still alive and well, right?
It's still alive and well. And these, in the realm of candy companies, particularly when people are making CBD gummies, they're making THC cannabinoid candies, there's this fascination that cannabis companies have with making things that look and sound like other products, like Skittles, or Skittles spelled with a Z. And what cannabis companies need to understand is, well, it may be popular product in the state you're in. While you may be able to make big bucks and really develop a kind of a cult following on your product, the companies who made Skittles or the companies who made Nerds, they've invested millions upon millions and billions of dollars in their candies over the years, and they will come after you. I've represented clients that have done just that, and the big candy companies come after you with threats of litigation and cease and desist letters. And if you don't take them seriously, you're pulled into litigation very quickly. And candy companies, they lose. Cannabis companies lose.
And Luke is talking in the comments about the Wrigley case, just another example of that. They're very serious about those brands. Incidentally, if like many of our clients have, if a operator receives a cease and desist letter, hey, we think you're infringing our candy trademark, clothing trademark, fill in the blank trademark. What are our sort of quick and dirty like suggestions for what someone, and other than just call a lawyer? I mean, like what sort of happens at that point, and what should people do?
Well, talk to a lawyer. I mean, I would say, but here's here are some thoughts. I mean, don't ignore it. I mean, because that is sometimes an instinct that some people have. Like, okay, well,
some people think it's like a form letter or something, or a trick, and you have to
right. Or I mean, don't. I heard, one time of someone who did not respond to a lawsuit because he said, well, I never got it, and then there was video of someone leaving it outside their registered office. This was in Hong Kong, so there were slightly different rules, but the point is, don't ignore these things. Don't think that you can just say, well, I never got it, so that's not going to fly. But at the same time, don't freak out. The fact of the matter is, a lot of times these letters are sent making claims that don't really have a strong basis. Once you have a chance to analyze them, sometimes there is room for negotiation. You get the whole range, right? I mean, we certainly, some of our clients have received letters that do suggest some bad faith on the part of the person sending them, and different ploys that people try. But we issue those letters, and we don't do it in bad faith. I mean, and sometimes we're not really looking to, or our client is not looking to start a fight. It's sometimes you have legitimate concerns about what's happening, and there may be room to reach an amicable solution.
With trademarks, you either enforce your rights or eventually at some point you lose your rights. So it comes down to kind of not only a good advice for people to send these letters, but when you receive these letters, it comes down to a big pockets argument. How much money are you making? How much money does the other side have to enforce their brand? And is it time to lawyer up and respond?
Well, and sort of just to put a bow on that, not only do you not ignore it, in my experience, the more sort of humble you are and the more willing you are to cooperate and show them the things they want to see and show them how many units you sold, and that, approaching it not in a totally adversarial way might help you make some sort of deal with them where you don't get as bad a result as you would if you ignored it. So I see our little clock is running down. minute 59 is running into minute 60. So we really appreciate everyone's time in attending the webinar and giving us questions and participating as we go. I think we'll probably talk internally about doing a part 2 because it was fun, and I hope you guys enjoyed it. Have a good day.